Okay, there we are. Good afternoon, everyone. Thank you all so much for joining us. My name is Liz Niles, and I am here with attorney Britt Burner. We are from Burner Law Group. We wanted to start off by thanking the Westhampton Beach Free Library for allowing us to put this together and present this educational webinar to our local community here in Westhampton Beach. Today, Britt will be discussing protecting assets. Should I put my home in a trust? And at this point, I am going to pass it on over to Britt.
Great. Thank you so much, Liz. Hi, everybody. It's a pleasure to be here with you all today. We are going to talk about whether or not you might want to put your home, your residence, into a trust. We're going to talk about different kinds of trusts, the pros, the cons, and why you might want to utilize one of those trusts. And we can also talk about different types of homes, right? We have primary residences, we have secondary residences, we have freestanding homes that are conveyed by deed, we have condos that are also conveyed by deed, we have co-ops, which are a different way of owning property, but still somebody's primary residence, and so still very relevant in this conversation. And so now we're going to dig in and dive into that. So the first question that a lot of people have for me is, what is a trust, right? So what are we even talking about here? So a trust is a legal entity. It owns things usually while you're alive. So a living trust just means any trust that's created while you're living. You would create the trust, which is a document. So you would put the terms of how the trust should be handled into that document and then sign it. And then it creates a trust. But that's not enough. The next step is that you have to fund the trust. You have to put stuff in it. So for example, when we are talking about that freestanding home or that condominium, the way that we put your home into a trust, mechanically speaking, is you would sign a deed giving your property to your trust. Now, what the implications of that are, again, are going to depend on what type of trust it is and what's written in the trust document. In terms of a revocable trust, that is a trust in which you can be in charge of it for your lifetime while you have your mental capacity. You can be what we call the trustee. So the trustee, I always say, is like the CEO of the trust. And a revocable trust will usually be written in a manner that does not limit you as the creator of the trust in any way. You can do whatever you want with that property. You can live in it, you can rent it out and get the rental income, which would be reported on your personal tax return because the trust would hold your social security number. You're the trustee. You can change the terms of the trust. You can change who the successor trustees are to you. You can change who the beneficiaries are. You can do anything you want with that trust. So the question becomes, why would you create a revocable trust? And the main answer is to avoid probate. Now, we're not talking about wills today. We're not talking about general estate planning, but we can't properly explain the pros and cons of creating and funding a trust while you're alive without talking a little bit about what a will is and what probate is. A last will and testament is a document that states your wishes and intentions for how your assets are handled and then distributed at the time of your death. Unlike a living trust, which is alive and well and a breathing document while you are living, a will has no effect until you die, and then the will goes through a process called probate with the court. A lot of people come to us and believe that if you have a will, you avoid probate. It's the exact opposite. Wills need probate, and probate is the process of having the will go through the court. You can't have one without the other. So if you have a will and your assets are in your sole name without a beneficiary, like let's say the deed to your home is in just your one individual name, then at your death, that must pass through your will, which must pass through the probate process in order for your wishes to be followed and for it to take legal effect. So that's what the probate process is. And a lot of people want to avoid that probate process for various reasons. One might be because you're disinheriting your next of kin, because probate requires that your next of kin receive notice that your will is going through this process. So if you're disinheriting one of them, you might not want them to get notice and be able to come to court and contest, because that's a waste of money on your estate, even just to fight them, even if they're not going to win. So if you're disinheriting one of those heirs that would get notice, you probably want to avoid probate. You would also want to avoid probate if you don't know who your next of kin are. So we have some people come in and say, I have no family. Well, everyone has family. The question is, how far removed are they, and how much time and money is it going to take to locate who those people are and satisfy the court that we've attempted to properly notify them of the will going through probate? We have a lot of times where we're sitting in probate waiting for what we call substituted service. We're waiting for the court to say, okay, if you can't find these people, then this is what's going to satisfy us. And it often requires a genealogist who can be, a costly expense on the estate, and other delay, and certainly delay in selling that property that's in your estate if you are in a situation where you can't quickly go through probate. So avoiding probate because you are disinheriting a next of kin, you don't know or don't know how to locate the next of kin. Let's say you own a property here in New York, but you also, or you live in New York, even if you're in a rental, but you own a piece of property in another state, like a condo in Florida or a small cabin up in Massachusetts. Well, in that case, if you don't have the trust, you would need to probate that will in both New York, where it was your primary residence, and in that other state where you own this property. And therefore, you have to go through two processes of probate. So that's another reason we like to avoid probate, owning property in multiple states. Now, if you have a trust and you take the deed to each of those two properties, where your primary is in New York and then that secondary residence, and you retitle them into the name of the trust, then upon your death, there is no court process, there is no notification, and the trust assets are distributed according to your terms. Maybe you leave one property to one person and then the other property to another, or maybe you leave the properties for the trustee, you direct that the trustee sells them and distributes the money that's gotten from the sale in different ways. You can put all of these terms within your trust document, just like you would in a will, to say what should happen. Another reason we like to avoid probate is if you have a disabled beneficiary. If you have a disabled beneficiary that can't represent themselves in the court proceeding, then the court will likely appoint what we call a guardian ad litem to represent the interests of that disabled person. Now, that is another report that has to be done, another investigation, another attorney court appointee who needs to be paid from the estate. So again, more delay and more money leaving the estate. And then another reason that we like to avoid probate, and more so post-COVID, is that we're seeing that the probate process is taking a longer time than it used to. And we have properties that are being held up by that process. So for example, if you have a primary residence there where you were living, it might be that we're in a hot market right now and your heirs want to sell that property immediately, but they don't have the authority to sell it from the will, from probate, until the executor is appointed. And if that takes 6 or 8 months, that could be quite some time before that property is sold. And is there money in the estate to pay the property taxes during that time, to pay if the boiler breaks and it's the middle of the winter and we don't want pipes to freeze? If we need to pay to clean out the home, is there money available to do that? And so the delay of probate can often be difficult when you own real property, because there could be waste and loss on the property as time goes on. Once you get into a condo or a co-op situation where there's a managing agent involved, It could be a further problem where your heirs could actually be, or whoever your beneficiaries are, could be kept out of the residence until that probate process is completed. And therefore, nobody can be cleaning it out, nobody can be readying it for sale, and everything is just sitting there. And so very often, again, we like to avoid probate for that reason. So for all of those reasons, we often like to create this revocable trust so that property can be owned by the trust. You have the full rights of it during your lifetime, and then it avoids probate at death. There are very few downsides to creating a revocable trust because, as I said, you create it, but it's under your own social security number. You can revoke it, you can amend it, you can change the successor trustees, you can change the beneficiaries, you can do whatever you want. Now, we have had certain times where a lender has an issue with a home equity line of credit or other lending to a trust that owns a property. Now, with a revocable trust, that doesn't tend to be an issue. I've only ever once seen that be an issue with a revocable trust. But my answer in that situation would generally be, you can just find another lender who will lend to the revocable trust because there's no downside to the lender. Once we get into irrevocable trusts in a few minutes, we'll start to see some other downsides. But with the revocable trust, there aren't a lot of negative parts of it. It is efficient in that it avoids probate. If you're living in your home and you're receiving home care Medicaid services, then Medicaid can't put a lien on that property at your death because they can only put a lien on probate assets. Therefore, the property, even in a revocable trust, will pass through to your heirs and avoid that creditor. So that's a very helpful thing for those who are not going to go to a nursing home and are going to stay in their home. As I said, there are not a lot of downsides. But the upsides are, again, you could sell the property. That money would all be in that trust and can be managed the way you state it's managed. And if you become incapacitated, that trust document can say how the assets and the property are managed within that trust and who's in charge. And then similar for after your death, the same thing. Who's in charge of the estate? That's the trustee. And how are the assets within it managed? A revocable trust is a really great tool when you have that piece of property. Because again, in order to avoid probate, assets can't be in your sole name without a beneficiary. Now, if you have a bank account and you put a joint bank account holder, that will avoid probate. If you have a retirement account like an IRA and you name a beneficiary, that will avoid probate. But when you're talking about the deed to a property, it's very hard to add someone else to it without there being a downside. So if you can change the ownership to be the trust, then it remains yours for your lifetime and passes on at your death without probate. You don't want to very often put somebody else on your deed or on your co-op shares for several reasons. One is if you're dealing with a co-op, very, very possibly they won't let you add someone to the co-op shares who is not a resident of the apartment and who doesn't financially qualify to be a tenant in the building. That's a separate co-op issue. But in terms of a deeded property, we want to be careful about how that property is handled for tax reasons. And so a revocable trust is a great way to transfer the ownership, avoid probate, but not change the tax character of that property. For example, if it is your primary residence, you could very well be receiving a veteran's exemption from real property taxes if you or your spouse is a veteran. You could also be receiving a star exemption for being a senior citizen or enhanced star. You can receive these real property exemptions when it's your primary residence. If you make it so that you don't own that property, then you could be losing those real property real property tax exemptions while you're alive. The other issue is a capital gains issue. If you purchased that property 40, 50 years ago, which for some of our clients, that was expensive 50 years ago, for $50,000. And now in this crazy housing market, it's worth $1 million. Well, you would want what's called a step up in basis at your date of death. That means that when your heirs or your beneficiaries inherit that property, if it passes through you or through the trust at your death, then when they turn around to sell it, they won't pay capital gains tax, because the difference between the date of death value, because the property will be stepped up, we call it, to the date of death value, that $1 million value. If they turn around and sell it, there's not going to be a capital gains tax because it is at that higher value. Whereas if you give it away during your lifetime, you take yourself off the deed, put somebody else on the deed so that they have the property, then upon your death, that individual will not get a step up in cost basis because you didn't own that property at your death. And so if they go to sell it for $1 million, but you gave it to them during life, they inherit your $50,000 basis. They're going to pay a very large tax on the difference between the $50,000 and the $1 million. Therefore, we like it to pass at death to get that step up in cost basis. Similarly, if that same person went to sell that property while they were still living, you would want to receive your own exemption from capital gains tax, which is a $250,000 per person exemption if it was your primary residence for 2 of 5 years prior to sale. So a lot of people get confused because they think this is a one-time exemption, but you can do it on any private, any personal residence, primary personal residence that was your primary for 2 of the 5 years prior to sale. So that's a really great benefit. The other type of trust that we very often create is an irrevocable trust. Now, that's a very broad term. There are many types of irrevocable trusts. I'm going to talk in general about 2 types of irrevocable trusts. One is an irrevocable trust created for Medicaid asset protection purposes. Now, in this type of trust, we want all the same character for tax purposes as the revocable. We want the step up in basis at the date of death of the creator of the trust. We want the $250,000 per person exemption if they sell it during lifetime. We want the real property tax exemptions. Therefore, we create it as what we call a grantor trust. The grantor is the creator of the document. The creator of the trust puts their assets in there. So since it is a creator trust, if we then rent that property out and there's rental income, that income is distributed to the grantor of the trust, the creator of the trust. So an irrevocable trust for Medicaid asset protection purposes, the differences between that and the revocable is that you cannot be your own trustee. Your spouse cannot be your trustee. You must choose someone other than yourself or your spouse. Now, it could be your children, it could be your sibling, it could be your cousin, it could be whomever you choose. It just can't be you or your spouse. But you can maintain the right to change the trustees of the trust and to change the beneficiaries of the trust. That's a right that you keep in yourself for your lifetime as the grantor creator of the trust, if the trust is written in that manner. You cannot have principal from the trust, and you cannot use principal in the trust for your property. So for example, if that property, your home is in the trust and you have a $100,000 checking account, you cannot use the $100,000 checking account to improve the property. Because if you do so, Medicaid sees that as using trust assets to benefit you as the creator, and therefore the trust is fully available to Medicaid. So when we're doing a Medicaid asset protection trust, you cannot use the assets in the trust to benefit you in any way, shape, or form. Now, if there is rental income from that property, you can receive the income. You just cannot use trust assets to benefit yourself. And you are, in order to, part of receiving those real property tax exemptions and all of that, is that in that type of trust, you must also have the power to exclusively use, occupy the property, and also the rights and responsibilities of maintenance, upkeep, utilities, etc. This is a very important point. When we talk about the pros and the cons, one of the downsides of this type of trust is some loss of control or use of the assets in certain ways. Now, the pro is that we have created a legal entity that has taken ownership of your property and protected it. So if after 5 years, your property has been in that trust and you need a nursing home, there cannot be any type of lien or attachment to your property. It will be fully protected, and you could apply for Medicaid to help pay for the cost of your care in a facility. That's a really, really great benefit. So we never get anything for nothing. So that's what creating this irrevocable Medicaid asset protection trust will do. Now, in other cases, people create what we call a QPERT, a qualified personal residence trust. Now, this has less and less application as time has gone on because our federal state tax exemptions are so high. But the general idea here is that unlike the other irrevocable trust where I want it to be yours for tax purposes, in this type of trust, I don't want it to be yours for tax purposes. So the idea is that if you have a $6 million home, then in that instance, we might want to remove that home from your taxable estate so that there aren't large estate taxes when you die to your heirs, to your beneficiaries, not to a spouse, but to the other beneficiaries. And so that's a different type of trust. Now, in a qualified personal residence trust, you are truly giving your home away. You can rent the home back from your trustees, but it's not like the Medicaid trust where you have continued use and all of that. You are then a renter in your own home. Now, because you've given it away for tax purposes, you also no longer have the benefit of getting that step up in basis at your date of death and the other benefits. So you want to be very careful when you are planning which type of irrevocable trust to use. We have to figure out what the goal is, what your other assets are, and also what the pros and cons will be based on the capital gains that have occurred since your purchase of the property. I'm going to pause for a second. I think we had a question come in. Let me just see. I think that this person, if the person who wrote in this question could write again, I think there's some parts of the question missing. I'd be happy to answer it, but I'm not sure exactly what it's asking. So if you could clarify, that would be great. Once your property is owned by your trust, and even in the Medicaid asset protection trust, as well as the revocable trust, you can sell the property. So let's say you have the Medicaid asset protection trust and it's in there and you decide you want to sell it and move in with a family member. Well, your trustee is technically, you can say, I want to sell the home and move, but your trustee signs the agreement with the realtor. Your trustee would sign the contract with the buyers, and your trustee would be present at the sale in order to ensure title to make sure that the trust was properly handing over the property. So your trust can sell it. Now, very important, especially in a Medicaid asset protection trust, if your trust sells a property, the proceeds of sale should be made out in a check to your trust, because if the trust sells it, the trust gets the money. And then that check should be deposited in a bank account that is in the name of the trust. If you break that chain and you put that money in your own name, you are undoing the protections of the trust completely. So you want to make sure that trust assets that are sold, that those assets and the proceeds of sale return directly to the trust. This is incredibly important. We have a real estate department in our firm and real estate attorneys. And that is a newer thing for us within the past few years. Actually, in February of 2020, we started doing real estate. And a lot of times we have clients who call up who maybe did a trust with us a very long time ago. And they say, well, I had a different real estate lawyer and they didn't know what they were doing with the trust because They're not a trust and estates lawyer, and they made out the proceeds of sale to me. Can I just put them in the trust now? And the answer is no, because now you've broken the character of the trust, because the trust says, the Medicaid Asset Protection Trust says that principal from the trust cannot go to you as the grantor, as the creator. And so if you've taken that money and you've put it in your own personal name, you have now violated the terms of the trust, and you run the risk of Medicaid seeing everything that's in that trust as being available to Medicaid since you broke the rules. So it's very important that if you are selling real estate, that you are seeking advice from an attorney who understands the nuances of these irrevocable trusts, whichever type of irrevocable trust you have, because it's not as simple as with the revocable trust where assets can move in and out at will. And so it's a very important point that you need a real estate lawyer who understands the nuances here. I see we have some people who've raised their hands. We just ask that you type your questions into the Q&A section. I think the question that's written in is about the capital gains exemptions. Again, the $250,000 exemption for your primary residence, when it was such for 2 of the 5 years prior to sale, can apply to the creator of a trust, depending on the type of trust that it is. So in that Medicaid Asset Protection Trust, yes. And in that revocable trust, yes. In the Qualified Personal Residence Trust, you start to run into other issues. But again, that is going to be the type of trust for those people who aren't worried about capital gains tax, who are much more worried about removing assets from their estate for the purpose of estate tax savings. Just as a mention, the current estate tax limits are that in New York State, you can't have more than $6.11 million upon your death. So that means that if your house is worth $2 million and you have a life insurance death benefit that's $1 million, that's already $3 million right there of your $6.11 million exemption. If you have other assets to add into that, brokerage accounts, retirement accounts, cash, in savings, checking, CDs, all of these things are added in to accumulate what your estate is. And if you go over the 6.11 by 105%, so getting to about 6.4 million, then you fall off the cliff, meaning you don't have any exemption and you pay estate taxes from $1. So it's a very dramatic fall off of that cliff in New York State. It's also use it or lose it. So if a spouse dies and just gives everything straight to the second spouse, then you lose the first spouse's $6.11 million exemption. All the assets have compounded in the second spouse's estate. So let's say they each had 4. Now the second spouse has 8, and now they're over that cliff, and there's going to be a large estate tax. So you want to make sure that you're doing proper planning to be tax efficient for the 2 spouses. On the federal side, we don't have a cliff. You're taxed on the overage is, of course, a higher percentage than New York State, a much higher percentage, but it's 12.06 million is the current exemption. So if the 2 spouses together die and right now and have less than the 12.06 million each, so that's over 24, then there's no estate taxes. But beware, because that 12.06 million, the current law is set to sunset, we call it, which means if you die after January 1 of 2026, that is going to go back to 5 million index for inflation. So we assume it's going to be just under 6 million is an approximate. And so it's going to be right around where New York is. So you really want to think about, if you have a larger amount of assets, doing planning to make sure you're tax efficient, because that 12 million is going to go away. For some people, that means lifetime gifting to trusts now. For others, it means being efficient between the spouses, if there is a spouse. And for others, if young enough and healthy enough, it could mean buying life insurance. There's a lot of different things that could be done. But if those numbers are resonating with you, that you think that you and or your spouse might be near those numbers together, you want to get proper advice. Going to look at the questions that have been written in. I think one was a follow-up from the capital gains question on the how we determine the capital gains tax, the principal. Oh, they're asking about the principal of the trust. So when I say you can't use principal of the trust, it's whatever asset is in the trust. So it's not the original purchase price of the property, as this person asked here. It's whatever the asset is in the trust. So if you have a house that's worth $2 million and you move it into a Medicaid asset protection trust, and then the $2 million, the house is sold and there's 2 million sitting in the trust, the 2 million is principal, and that's the asset that cannot be touched. Whereas if that 2 million is invested and shooting off income, the income can be touched and used by the creator of the trust. There's a question about a condo, and I'm not sure what the question is. So if that person wants to clarify, I think that would be helpful. So someone asks why a neighbor would sell their home for $10 to their children. I don't do that. To me, now your children bought a home for $10. So if they go to sell it, their capital gains tax is going to be through the roof. If that home, as this person says in their example, is worth $800,000 because their cost basis is $10. We do, when we transfer assets into a trust, we call them no consideration deeds. So no consideration means no money changed hands. I don't see a value in putting a $10 amount on that. And then there's a question here about why you would do an irrevocable trust instead of revocable. And the answer is for Medicaid asset protection. The Medicaid asset protection trust is done so that if you need a nursing home, that home is completely outside of your name. And if it is sold, whatever's done with it after that 5 years, it's totally protected. And that is the main reason to do the irrevocable Medicaid asset protection trust. If you are doing the other type of irrevocable trust that I mentioned, you would be doing so to minimize your taxable estate if you thought that you were going to go over those exemptions that I was discussing. If there's any other questions, please feel free to keep writing them in. So how would a no consideration transfer be valued for capital gains? So the question would be, where are you no consideration transferring to? That's why we say to do a no consideration transfer to a trust, because then it's, if we do a Medicaid asset protection trust or a revocable trust, then for capital gains purposes, we're still using what the individual purchased it at, and the transfer to the trust is irrelevant to the conversation. If you do a no consideration transfer to your children, that could create a capital gains issue, as I described. We generally do not recommend that being done unless it's a really rare and extreme circumstance. We do not recommend a no consideration transfer to another person. You cannot get nursing home protection with the revocable trust. That's another question here. The revocable trust is fully available to you. So if you need a nursing home, they're going to see that house as an available asset. The only reason it has any protection as a revocable trust for Medicaid purposes is if your home is under the Medicaid limit, which is about $950,000, if that's your equity is less than that, and you're living in the home, then it's exempt for Medicaid purposes, and avoiding probate through the trust avoids the lien. That would be the same if your spouse is living in the home or a disabled or minor child. Can you switch revocable to irrevocable? You can. You could restate the trust. in order to make it irrevocable. And we have done that. And in other circumstances, depending on how the original revocable was written, we sometimes will create a new irrevocable trust and just move the assets into the new trust. However, realize that when it's switched from revocable to irrevocable, that's when the 5-year look back would start for the nursing home, not when the original transfer to the revocable trust was made. There's a question here about if I think New York State Medicaid will move forward with the community Medicaid look back. I will not give my opinion, but I will say that there's 2 current barriers to this happening. For those who don't know, there is a law that was signed in April of 2020 as part of the budget in New York State, which said that there would be a 2.5-year look back for community Medicaid. That would mean that if you transfer assets, that there would be a penalty assessed if you needed home care Medicaid within 2.5 years of those transfers, similar to the 5-year look back for the nursing home. That has not gone into play for 2 main reasons. One is because during the public health emergency of COVID, while the federal government has a public health emergency in place, we cannot change our Medicaid program. So until that ends, we will not be able to have a changed program. We would lose federal funding. This is why it keeps getting pushed. So for those of you who say, well, it was January 1, and then it was April 1, and then it was July 1, and now they're saying October. It's because every time the federal government, the president extends the public health emergency, it pushes that off from happening. The other thing that hasn't happened yet is that in order for it to go into place, CMS, the Center for Medicare and Medicaid Services, must approve our request to change our Medicaid program. And that request was submitted last spring, and we haven't heard anything from CMS. So we don't know if we will never hear something and it'll just sit on a desk, or if at some point they will pick it back up, or if they will reject it. And so those are the things that we're waiting for in terms of the look back. So all I can say is that right now, we do not have a 2.5-year look back for community Medicaid purposes. I answered that one. So someone's saying they're leaving their home to their 3 children. What are the tax implications? There are no necessarily negative implications based on who you're leaving it to or how many. You just want to make sure that you're leaving it in the most efficient structure. So as I discussed, do you want to do so through a will? Do you want to do so through a trust? You either way want to make sure likely that it is part of your taxable estate at your death to get that step up in cost basis. And while you're alive, you want to continue to have it where you can continue to use the property and get all of your real property tax exemptions. Okay, I think there's some questions here about the irrevocable trust, but it's hard for me to piece together because I don't, just so you know, when I get the questions, I get them in the time that they come in. So I don't have them in order. If you've sent in multiple questions that are really just one question compiled. I'll just say that if you do a Medicaid asset protection trust, all tax consequences and liabilities pass through to the individual if it is created properly as a grantor trust, and the trust does not pay taxes while you are living. And I think that's all here. There's a question here about the costs of creating trusts, but I don't want to discuss cost on this. This is really meant to be educational, and every situation is different. So what I'll say is that having a consultation with an attorney to discuss your situation and to determine exactly what documents would benefit you and those you want to leave assets to is your best bet. And then from that consultation, you could determine, the attorney would determine for you what the cost might be. Next question is, why do you need a will if you have a trust? That's a great question. I'll give you a perfect example. I created a trust for a client several years ago, and we did all the work to transfer all of her assets into that trust. For some reason, I have no clue what the reason is. There was one bank account of about $100,000 that didn't make it into the trust. I didn't have it on my original list, so I don't know if she didn't know it or if she split it off and it was created later on. But whatever happened at the time of her death, there was this $100,000 that was not owned by her trust, was in her sole name, and had to pass through probate. So what we had in her case was a will that was created as a companion document, which was what we call a pour over will. So it said, upon my death, if there's anything in my name, it has to go through probate, but pour it to my trust. And it was important in her situation because the beneficiary who she had named for everything, the beneficiary of her trust, was a person who needed someone to further handle his assets for him. And so it was very helpful that that happened. Another situation is someone who dies as a result of negligence or some other offense that could create a lawsuit. And if money comes into the estate after death, you would want it to be properly directed. And so that is another reason why we like to have the pour over will or a will as a companion document to the trust. There's a question here about the rental property in an irrevocable trust and the capital gains tax. Again, if it is created as a Medicaid asset protection trust, which is what we call a grantor trust, if drafted properly, then the capital gains tax consequences flow to the individual person, not to the trust. The next question is, what is the benefit of a TOD? TOD is transfer on death. It is a way in which you can name an after-death beneficiary on an account that will avoid probate. In some circumstances, that's a perfectly great part of the plan. In other circumstances, it can be difficult because let's say all of your assets have a beneficiary named, and then upon your death, the only asset in the trust is a property, but somebody has to pay to keep that property going until it's sold. If there are no assets to go along with that property, well, then in that case, how does the trustee keep controlling the property if everything has been TOD or gone to the beneficiaries individually? So TOD can be very helpful in certain circumstances to avoid probate, but you want to make sure it's part of the larger plan. The difference between a life estate and a trust. A life estate is a power that you would reserve in a deed. So if I own a property and I give the property to my daughter and I reserve a life estate in myself, that means that according to the IRS, I own a percentage of my property as the life estate holder, and my daughter owns the balance percentage of the property as remainder person. And as I age, my percentage of ownership decreases. And there's a life expectancy chart from the IRS that determines this. So if I sell the property while I'm alive, I only get my small percentage of the sale, and my daughter gets her percentage as remainder person. The benefit of a life estate is that immediately upon death, the asset belongs to my daughter. But often that is not a great plan to use life estates. That is a little, we do them a little bit here and there, but for the most part, it's not a great part of the plan. Because say that house needs to be sold and you're in a nursing home, now all of a sudden your percentage of the property, that proceed goes to you and it's not protected. Whereas if instead of that life estate deed, we had done a trust, 100% of the property would be protected. There's also other benefits to passing assets through a trust so that upon death, they go into a trust for protection for your beneficiaries, which you lose in a life estate deed. So I won't say never to do a life estate deed, but in general, we would prefer a trust as a way to transfer ownership at death over a life estate. I think that's all of our questions for today. So thank you everyone for joining. I really appreciate it. I hope you all have a wonderful Memorial Day weekend. And we get some nice weather, and I will see you soon. Thank you. Have a nice day.